Hi, today is the 22nd of April. So I did a first video on introduction to tort law, which is mainly about negligence. So will be a continuation of it. Um, yep, I have it will be more for general knowledge, but it's more for law students. Okay. Um, so first thing I'll talk about the introduction. Then I'll talk about uh, the different categories of duties of care, economic loss, public bodies, omissions, and I'll talk about causation, and then I'll conclude. Okay, first thing, introduction. You have to realize that there are different countries have different systems, and is like for example, pure economic loss, Germany and follows a bit UK that they say general rule cannot, whereas France say can. Australia and United States, they have put it in legislation to make it harder to claim. Then for example, punitive loss, right? US, they allow for damages. You can claim very high, like the case of McDonald's, right? The jury awarded them 2 million, right? The victim, he got burns all over the body because of hot coffee, and then later it was reduced to 600,000, then subsequently settled for an undisclosed amount. Yeah, but so the limit lah, if you don't you never suffer much loss, is different. So for example, UK, if you get injured, or sorry, in US, the damages for paralysis or something is about 500,000. It can go up if the jury want to give you 2 million also can. Whereas Malaysia is very little. Malaysia is like 300,000, the maximum of bodily injury, right? Physical injury, maybe 300, 400,000, the max. You go blind, you lose two limbs, two hands, something like that. It's not much, Malaysia. So even though we say we follow the principles of UK law, when it comes to calculation of damages, you might not get so much as other countries. So I prefer to be practical. When I study law, I don't want to just know the textbook stuff, right? So you want to know what is it in real life. So the statistics, okay, number one is I got this from the textbook, Mark Looney. There are 80% of the UK, based on the latest statistics, which is maybe 10-20 years ago, there are 80% is motor accident of tort cases. Okay, 2% is clinical, 9% is public bodies, 8% is employer, means the employer negligently injure the employee. Right, so even based on, I never even study one single case on motor accident, but I say motor accident is 80% of the time of the cases, right? So yeah, and you see, and it's a lot to do with reasonable foreseeability. When you want to see whether there's a duty, when you want to see whether it's a breach, whether there is a remoteness, causation, they consider reasonable foreseeability of harm, right? And so reasonableness is a degree, okay? That's why in exam, when you do problem question, you can always argue. Very easy to say one side can say there is duty of care, there is a breach of duty. The other side, you can always say the opposite, because reasonableness, who knows what is reasonable man, and they always protect physical injury and property damage, because forcibility, you can see the thing. If I damage you, if I injure you or damage your property, I can see it's quantifiable. Whereas economic loss, how do I know how much money? If I'm the auditor, I produce a financial statement. You go and invest in a company 10 million. How I know? How can I see you are going to invest 10 million? No way, ma. And not only that, but your body is very important, more important, right? Because you cannot compensate. Money, so what? Money is, you can get back, ma. Yeah. So that's why one thing I don't like is when the law say that public bodies, very hard to sue the police, right? In the case of Michael and Chief Constable, you already die. No, you're suing the police maybe how much? 500,000, 300,000. What is it to the police? One life has been lost, you know. It's not like US. If US you can sue for millions because the jury, if you make a very sad story, you know, now I got I lost my wife, I lost my children lost their mother, you know, you tell the jury your sad story, she was such a good woman, you know, now you have lost somebody, and then the jury will feel pity for it, the jury can give you a few million also, right? But UK no UK is no, how much, so why you have to make it so hard for people to sue, you know, the public bodies? And that's why, and Malaysia, we most likely we will follow UK of course there I don't, yeah, most likely lah, but so it's not much when they say that they want to, you know, they don't want taxpayers money, yeah, not much, right? Anyway, um and in bodily injury, right, once you prove forcibility of harm, automatically prima facie not automatic, prima facie there is a duty of care already. In right, this what I got from Nolan, Robert, I think Robert Nolan, or he's a academic lah. So I got this from a Malaysian textbook. I forgot where I got it I think it's from Nolan. So he said that actually people don't really argue so much on duty of care in practice, they argue more on causation. Okay, normally duty of care is only for the three categories psychiatric injury, pure economic loss, and public bodies, and also maybe omissions you can consider the fourth one so yeah, but in academic we focus a lot on duties of care, right? And causation will be hard in real life, and you want to yeah, but how it developed, you see how the history of negligence started is of course they always say it started from Donahue and Stevenson, right? Because before that nobody really say what is the principle, when do you have a negligence claim, right? Until Donahue and Stevenson, they say the neighbor principle. Lord Atkin say neighbor principle, as long as you know you have a duty to your neighbor not to cause injury, right? So but it started because why it started so late is because last time there is no technology. Once you have trains, you have cars, you got guns, you know, you got police got gun, you know, all these weapon, modern technology, very easy for strangers to injure people, you know, very easy to injure those people around you lah. And then yeah, and last time it was strict, so the moment somebody harm you, you have to compensate. Then later on they say there must be a breach of duty, you must be at fault not necessarily maybe it's a pure accident, then you don't have to pay. Now is the case, then industry can grow if not people all the time scared to do business, scared to do things and it started first, they say you must they foreseeability of harm, right? They say is not enough, okay, because it went on to from Donahue, which is forcibility of harm. Later it went a few other cases, and then they say it's not enough. You must have the policy. Policy means there is no policy fighting against you, against denying you duty, right? And then later on, lastly, there was ends. Ends was the two-stage test, right? You have forcibility of harm, reasonable forcibility of harm, and no policy against. Then later it went to Kapao, now got proximity, and one more is proximity. So proximity, the difference is you bring in policy considerations into proximity itself. Right? Proximity is also like physical. It can be physical. You next door, or you some guy in America, you know, right? Not near enough to sue me for negligence right? Yeah. So it's slightly harder for Kaparo 3-stage test and ends 2-stage test. So and when they say the 3-stage test fair, just, and reasonable, right? Kaparo added fair, just, and reasonable. So this one, I read a textbook, I think it's Clark and Linsell. It says that some judge, I think, or I don't know, is it the author or he was quoting a judge that say that it is an ordinary and common meaning. right? What people say lah. So when you are fair and just and reasonable, is between the two parties. Let's say you sue the police, right, or you sue your employer. What is fair between you two guys lah? But some people like Lord Brown Wilkinson, they say no. It's actually you have to compare the cost to society as a whole when and the potential benefit to the potential victims or the potential claimants. You compare, is it higher, which is higher, right? Cost versus benefit. So it's something like a policy lah. And this one you won't very hard to prove. You don't have empirical evidence, statistics. So they say he say you rely on instinct lah to judge lah, right? But so um, slightly this one I don't know, because I read all the textbooks, they never really define what is fair, just and reasonable lah. Different people got their own different understanding of what it is. You have to go back to the original case of Kapao to see what they actually mean, but how they apply lah after Kapao, how they apply in all the other previous cases lah. But most of it they will say is policy lah, right? Yeah, but maybe exam you go through both. And but later on, now we got Robinson in 2018, right? Robinson say you don't look at the Kapao 3-stage test first. You look whether there's a precedent analogy from existing cases that they have a duty, then can. But even you cannot find, if it really is a really new case, then you go through the Kapao 3-stage test lah. But and they keep saying there is no general principle lah. In Robinson also they say that there is no general principle of when there is a duty of care. And they say even though there is a new case, it's not a reason to deny a duty of care. Yeah. So the purpose of negligence is to three things lah. Main things is compensate the victim. You want to guide actions, or you want to prevent the mistakes from happening again, and you also want justice lah, retributive justice lah. Okay. But at the same time, this is all to give the claimant. Okay, the claimant will say, hey, this is the purpose of tort law, so you should give me, duty of care lah. But the other guy will say, we don't want everybody to blame somebody the moment something bad happens. We want people to take responsibility for their own self. Even though somebody was at fault, somebody was careless, but you could have done something to protect yourself. So you should bear the loss. They don't want people to be dependent. Every time look to the government for help. Look to the courts for help. Because why? The courts now, but Parliament stopped their, they limit their funding. So they got very little judges now. They had to close down a lot of courts, and they had to let go a lot of judges. Small one the magistrate level and the session court maybe, I don't know. But so they are full. Backlog is totally 5-10 years. So last time my Lord Denning say civil case 3 months only you be heard. When he first became a judge, it was only 3 months. Contract law case is 3 weeks. Now it's how long? Now a few years or so. I don't know. It's like, yeah. So they both sides will say the other thing and so we have to and not only Kapao. Besides Kapao, you have this assumption of responsibility, right? Where for pure economic loss, not only for pure economic loss, for negligence in general, you have two now. You have Kapao and you have assumption of responsibility. So if you call police say, don't worry, you stay at home, I will come. Don't leave your house. You stay in your house, the robber come and kill you, right? The police are responsible because they promise you that they will come. So there's a voluntary assumption of responsibility. The voluntary there is quite debatable what it means. Okay, some people say just the police is doing their job. They are telling you they will come. This is their job. It's not really voluntary, because it's a contractual duty, or it's yeah, it's their duty to do something, so it's not voluntary, but if they do something more then it's voluntary. Whereas some people say it is enough because voluntary assumption, it can be implied, it doesn't have to be expressed also. I don't have to promise you I'll come also. If it's implied that I will come, then yeah, when he fails to come, then there's a breach. But so whether it's implied or expressed, what is the definition of voluntary? You dig through the text, the cases okay. But different, what I read is different people there's some debate on it and so assumption of responsibility is harder to satisfy than culpable. So the moment you have assumption of responsibility, you don't have to look at culpable three-stage test anymore. Like it comes assumption of right, because some judges even say that assumption of responsibility is actually part of the three-stage test, because when you assume responsibility, you satisfy the proximity test. Lord Huffman say when your assumption of responsibility, it is just fair and reasonable to impose a duty. It is part of the JFR test, just fair and reasonable. But some say no, assumption of responsibility is separate, but most people will say it's separate. And once you have AOR, you don't need three-stage test, but it doesn't mean you need both. Okay, sometimes you don't have AOR, you can have three-stage test. Sometimes you got three-stage test, you don't need AOR. Okay, but in general, AOR is harder to meet. Okay, and yeah, so okay, so now I'll go on to the specific category of pure economic loss. So normally they always say Spartan Steel tells you what is pure economic loss, but actually when I read the textbooks, it's not so much telling you what is pure economic loss, right? But when Lord Denning say that why he disallow the claim for loss of profit, right? Not loss profit for the sale of the damaged goods, but loss income that could be generated during that time when the factory was shut down. Right? Lord Denning say cannot because it was a policy reason. He said that it is better for the risk of loss to be borne by the public instead of the contractor, because public can buy insurance for business disruption, for example. So you don't want to put all the risk on the contractor who fail, accidentally cut your electricity, right? Yeah. So it's and he don't want to prevent floodgates, because if you allow speculation, I can say during that 2 days I could have made $1 million, now you must pay me one. It's like how to prove in court. Everybody will submit a claim, the court will be court the one yeah, so it's more for this. But Malaysia is slightly then later on, okay, so in UK, then we have Ants and Merton and Murphy and Brentwood. It's like, so Ants and Merton was say you can sue right, the house buyers. The building is defective, you can sue the surveyor, or you can sue the architect, or the local council who approved the building because they inspect the building and then they didn't do correctly But then Murphy overruled. Murphy said cannot. Okay, because it is for one reason it is pure economic loss another reason is because it's the government But and Murphy, one reason why, the very strong reason why they say cannot, is because the people who were suing was the insurance of the house buyers. So the insurance of house buyers make a profit from the premium. So when a damage happens, they want to blame and recover the money, from the government, right? Of course, they say you earn your money, now there's a loss, then you are in a better position to bear the loss. But Malaysia house buyers, we don't have right, defects against negligent third parties, right? Even contractor negligence also, we don't have such insurance, right? I don't think so. I never heard of any company any insurance for that. So of course you can, if you're a very big company, you can get a policy I'm sure. But then like most, let's say you are residential or whatever, I never heard of anybody buying that before. So that's why Malaysia we don't follow Murphy. The courts, one of the reasons they don't want to follow Murphy, and most Commonwealth countries a lot not a lot don't follow Murphy also. In Malaysia, the position is we look at each case and the facts whether it is just, fair and reasonable, right? To impose the duty, because there is no privity or contract. So UK, if you are not a party of the contract, you cannot sue, right? The architect is contract is the developer or the contractor. You don't have a contract with the architect. How you want to sue the architect, or how you want to sue the local council? Uh, right? So they respect UK, but Malaysia slightly easier, and in New Zealand, all local councils are owe a duty Okay, in fact, New Zealand they have an insurance scheme to cover all negligence claims. Right, very special country in the world So negligence claim, all covered by insurance. So even the defendant also don't have to pay. There's a special scheme and some people will say it's not foreseeable. The architect or the engineer will say it's not foreseeable that if I'm negligent, how do I foresee the harm that the guy will suffer? But the court say there's a case that he can. Okay, because you can foresee if you are negligent, they will have to spend money to repair the building, right? So it's foreseeable Okay. Yeah. So we want to look at causation now. Okay. So causation one, I will start off. Most of the cases in the textbook are about medical negligence because it's scientific. It's how do you prove you cause the guy who die, right? If I suffer from cancer, okay, I got 51% chance of dying, right? So even if the doctor is negligent, I die, he didn't cause my death. The cancer caused my death because based on the but-for test, you have to prove based on balance of probability, which is 51%, 50 and higher above. So they were based on your what, but how sure are you that your scientific evidence is that accurate or not? That's one issue And even if he caused your death, let's say he caused your death 49%, 51% they say is because of the cancer, totally cannot claim, Whereas if it was economic loss, if your lawyer, okay, there's a case called Allied Naples, if your lawyer was negligent, advised you wrongly, and if he gave you proper advice, there was a 30% chance, let's say, of the other party agreeing to your terms, okay, and agreeing and signing a contract. So that 30% you can translate into damages, right? But personal injury, Hodgson, the case of Hodgson say cannot, because they adopt this all or nothing approach, and there was split decision. 3 agree, 3 say there's no causation, 2 says there is. So Lord Nicole, he dissented right? He said because one of the reason is you don't know there is scientific uncertainty, and evidential uncertainty. So because of that, you deny causation, then is what now? And another issue is when you have 2 parties at fault. So if the architect and the engineer both are negligent, the building collapse, architect will blame the engineer. You say, even if I was doing my job okay, the building will still collapse because the engineer is negligent. The engineer will say the same thing to the architect. So applying the but-for test, nobody caused the building. None of them, either one of them caused the building to collapse. But they will say, no. We will apply, if there are multiple parties, they will apply the material contribution test. So if you cost 50%, he costs 50%, both of you share the damages. Yeah, that is one way to do it. So another issue is when you have multiple causes, the multiple contribution in multiple parties. Okay, when you have multiple causes, right, then it's not so easy anymore. When, for example, this case where the baby was given too much oxygen, the baby was premature, so they gave too much oxygen, baby became blind. So they already know that if you put too much oxygen, you can cause blindness, yes. but the baby was also born with some disease, so there are four other reasons why the baby could have gone blind. Okay, so there's not sure is it which one, is it the oxygen or is it the four other causes that cause the baby to go blind. So because you cannot prove based on balance of probability, even though it was careless or what, you cannot claim damage, you cannot succeed. Yeah, so that is you want to yeah, that's why medical is one of the issues lah. Okay, and some judges I read, like Australian judges and Malaysian judges, they say it's common sense. Okay, like when there is a landslide, the building collapse or what, you can blame the rain, right? You can say the rain, heavy rain cause it. When there's a flood, you just say heavy rain but common sense they will say you yeah. So like the boy climbed the electrical pole, right? There's this case, he climbed the electrical pole, he got electrocuted. The company say, the defendant say the boy caused the death who asked him to climb. But the court say no, when you put something so dangerous, you have to know that there's a possibility that children will play with it, so you have to put safety prevent them from climbing, or you need to put warnings or something. Yeah, so and go back to Hodgson. Hodgson, they argue that there is a loss of chance. The academics say loss of chance itself got a value, right? Even if you 51%, you have 49% to recover. Like in case of Hodgson, he went to hospital, he got misdiagnosis. Right? When he came back, too late already. After 4 days or what, he was paralyzed in one of his leg or something So, but if they had properly diagnosed him, there was a I think 25% to 40% chance he would have recovered. And they say that 40% chance is not enough, right? It has to be 51% above. But even that 25% to 40%, there is some economic value, right? He lost the chance, like when you play gamble, you go to casino or what, there is a chance that you might get. So that is some value, but the courts don't recognize it, yeah. So and it's based on they can be quite complicated when it comes to all this. Of course, now we go to public bodies. It's only 28 minutes. So the public bodies, the main question is why we got a separate category for the government. Why so special? Everybody is the same. Why the government? You see, we got the constitutional principles, right, of doctrinal doctrines with parliamentary supremacy, rule of law, and separation of powers. Malaysia different okay, but we talk UK first. So parliamentary supremacy says when you go to a breach of statutory duty, you always want to look at what is parliament's intention when they have the act. And they say, some judges say, if the act is silent of allowing you to sue under tort, a private law, right, then presumption is cannot sue. But the Law Commission in I think 1960 something, they suggest that it should be allowed. When it's silent, the presumption should be yes, there is a duty, there is a ability to sue under private law. Yeah, so I don't know whether can or not, but so it goes back to statute interpretation. They always want to interpret the statute and there are some rules to it whether you are the intended beneficiary of the statute or something right? There are 4 or 5. Yep. So that is and the statute, but they always like to say that yeah. So how about separation of powers and rule of law? Because separation of powers say the court, we need different organs the judiciary to prevent abuse of power from the executive, for example. So the executive is really useless. Okay, we can say there is judicial review. Okay, you can sue them under judicial review, but you must remember judicial review don't give you compensatory damages. They normally give you nominal only, right? They will give you injunctions and they'll give you specific orders but yeah. So why can't they modify it? Why allow? Because judicial review will say it's wrong So okay, this one I'll go into it later. But there is separation of powers. Okay, so when you say you are not equipped, you're not the issue is not justicable for the courts to look at, because they say police, how the police investigate, we are not equipped, but you can do that for other professionals, doctors, lawyers, accountants, auditors. You can do that, you can hear the case. But when it comes to police, I don't want to hear, because it's not my expertise. But why, you know? And not only that, but how about rule of law? Rule of law say the law should apply equally to everybody. Nobody is above the law. But why do we have two sets of rules? One for the public service, and everybody, all the other defendants have the different kind of level. Why is so special about the government? Yeah, and even if you want to develop your doctrine, you want your doctrine to develop incrementally, right? Like Robinson, they say you want to apply analogy first. There are some arguments, like in the Supreme Court of Canada, one judge said, tidiness of your doctrine or principles is not a reason for you to neglect justice. Justice must always, the judge say, it's more important lah, right? So, but of course UK don't adopt that stance lah, thanks to Robinson lah. But and also thanks to other cases lah, okay, before Robinson. But we want to sorry, where was I? Yeah, the rule of law. Why is it separate, correct? And later you will see lah, especially in omission, okay, you will see that it's very different, because omission, if I have a contract, there's an exception. Omission, there is no duty to save anybody. If I see somebody drowning, I have no duty to do anything. I can sit down and watch him die. Like in US, there's a case. The whole is an apartment, the flat, right? The woman shout, "Somebody stab me! Somebody stab me!" Everybody just stay in their condo, in their flat, and do nothing. Nobody come out. Nobody call police. Nothing, until one guy decided to call the police, but that time too late already. She was already bleed to death already. So based on I don't know what happened to that case lah in US. Okay, but in UK there is no liability. I think US also same lah. They fail to sue. They fail to what lah. So but there's an exception. One of the exception is if you are under a contractual duty, right? If you fail, let's say you need to close the gate every night, you fail to close the gate, somebody go through the gate and get banged by the train, right? There's a case, criminal case. Then you are guilty, right? He was guilty lah of gross negligence, manslaughter. Imagine if just forgot to close the gate one night, one guy ran the train, banged him, he got prison. But the police, the government, apparently it doesn't apply. If I understand correctly, okay, contractual is not an exception, because the police is under a contractual duty ma. Whereas Malaysia different. Okay, Malaysia, the police are under a statutory duty to assist, to protect, and to protect property and life, and to apprehend people that they are empowered to apprehend lah, which is what lah. But they, when the police was sued in UK, they say no. Okay, in the Michael and Chief Constable 2015, even though the police didn't come, okay, the lady called, the police said, "I will transfer your call, to the correct department," but no police came. She was murdered, right? Because she passed the wrong message. She passed the message that it was not a very urgent issue. Actually, the guy already threatened to kill her, and she was very frightened. So by right, the police should have sent, right, category 1 lah. They should send the car immediately. But they waited 6 hours or 2 hours or something lah. And then later when they call her, it's too late already. When they call her, she was shouting, "Help, help, help!" And then, pop, she died. And then the phone dead. And then when they come, she's dead already. So, but the House of Lords say there is no liability, general liability for an omission. It doesn't recognize. Of course, there are exceptions lah, but yeah. So, strange because when we are under a contract, we fail to do things, we kena, we are under a duty of care. But the police, the ambulance, the fire brigade, or whoever lah, whether it's social services or what, they don't have to do anything. They don't have to rescue you. So even if you are drowning, right, no need. But of course, private citizens have to. So as I say, it doesn't comply. It's not constitutional based on rule of law. But Malaysia different. Malaysia, we are constitutional supremacy. So we have to argue based on based on the what rights to life and all those lah. Okay, but so that one I'll talk about human rights later. But Malaysia, okay, but see some of the reasons why I found that why they have a separate category for public body is because like they don't want to tell them, the government, how to do their job, because parliament is supreme. Parliament give power to all the public bodies. If they go and interfere, it's like they are campur tangan with the parliament lah. They think lah. And yeah, but like I say lah, separation of powers, you have to right, you have to look at the executive decisions and when they say taxpayers end up having to foot the bill, but it's not much like I said. When you have personal injury, when you have property damage, it's not much. Maybe economic loss can be a lot lah. Let's say in US, the regulators, right, they fail to control the rating agencies, so you got the subprime crisis. A lot of people lose. Lehman Brothers bankrupt. The other banks also almost went collapse, right? And the financial system almost collapsed because the rating agencies and the regulators didn't do their job. So if you are going to compensate for a pure economic loss, it's going to be in amounts of billions. Maybe you can say lah, but UK, it's not so easy to sue for pure economic loss, right? So why I understand the reason for limiting pure economic loss, but now they are doing it for even personal injury, and taxpayers not much the compensation, like I said. So when you say you open the floodgates, in UK, the losing party will have to pay the winning party's cost. Your legal fees is going to be a lot. You go up to Supreme Court, you go up to Court of Appeal. How much is your own legal fees? You have to pay the other guy's legal fees also. Malaysia, of course, the cost is not so much because Malaysia has different rules. Malaysia maybe 5-10,000 but UK 50,000, 100,000, 200,000. So if your case is not strong, you are never going to go and sue the government. You are never going to sue anybody in the first place if your case is not strong. Of course, maybe they say you want to settle, you want to get a settlement, and you want to what lah? Maybe they just want to file a case. Hopefully the other guy will settle it lah. That is possible. But if the government is so strong, their case, they know their ability to win is very, very high, and they got a lot of money from the government, right? Because the Solicitor General will help them to fight the case They don't have to go and hire a lawyer, whereas you have to go and find your own lawyer to fight the case. So floodgates not necessary also and when they and then sometimes they say, so debatable lah. So sometimes you say they distract the so in all other professions, you are you have a boss. Your boss will oversee your work, right? You got controls to look at it. When you deny the avenue to public bodies, so it can be bad, because you got nobody to check their work, even though they got like some stupid policies, okay, right? No, of course they will say if you really disagree, or then you can sue under judicial review lah, right? But the difference with judicial review and tort is different, okay? Because they always like to speak. They say public bodies, yes, you can sue. Now, because last time it's quite hard. Then later on, lately, I think starting on a few other cases, now it's generally recognized that you can sue a public body, except when there is an omission, when they fail to do something. But when they make a situation worse, okay, the fireman come, he make the fire worse, he turn off the sprinkler, and then the fire will become even bigger. Then he's negligent lah. There's a duty of care. But if the fireman never come at all, right, you call, he never come, then there is no duty to rescue to come and help you. You know, when they repair a wall, your wall, you got flood, you got the wall, the retaining wall broke, right? If he never even touched the wall, then okay. But if he, so it's what is an act, what is an omission? They say it's a physical, what you actually physically lah. Okay. So go back to judicial review. They always like to split between policy and operation decisions. Policy, you cannot sue under tort. They will never allow you. But it's a degree. Okay, they have already recognized that it's a degree. Some decisions, some actions fall in between a spectrum, right? And not only that, but policy can be bad also. Some policy is really stupid policy. Okay, governments, companies, they always have some stupid policy one. And they say that the correct way for policy is to file a judicial review. But you must remember, if somebody already died, somebody already injured, judicial review is too late. In judicial review, you only got 3 months, the limitation period. Whereas tort, you got 3 years. Right? Malaysia is, I think, 6 years. So, it's a lot shorter lah for judicial review. And judicial review, you only get like nominal damages lah. So, yeah. But too bad lah, okay? They only allow you at the moment is operational decisions lah. So you don't sue for policy. So for example, this guy, they adopt children, right? The welfare children, the home, the orphanage home, they don't want to release information, all the bad things about the child, because they want the child to be adopted ma. So their concern is the child's interest. But the parents, they want to know everything about the child, before, but they never. So when they adopt, the child is like, super naughty or what, give a lot of problem. So they sue the council, or but they say it's a policy decision. It's their right to decide what policy they want. Yeah, so this is one of the examples. Okay. It can be a stupid policy also, right? What happens if they come out with a policy, they say, we are not going to tell you anything bad. The moment something bad about a child, we only tell you the good things. It's a policy, but it's a stupid policy, right? It's a negligent. You can be negligent in making your policy. Put it that way. But of course, they haven't reached that kind of case yet. Yeah, so talking about the taxpayers, right? You see, some people, they say, one of the textbooks, they say that isn't it better when somebody is injured and they are not at fault, it was a pure accident, shouldn't the community as a whole so-called help the victim lah, right? So using taxpayers money, why not? Like the government, the recent flood we had a few months ago, was it? Yeah. Right, the Selangor government hand out I think 100 million or something, right? So even though they are not under a legal obligation, they giving it out of compassion. So there is some moral thing about it, right? When the government help the victim. So even more, because some say people will sue the government because they think government got a lot of money. But because government got a lot of money, maybe it's a good thing for government to help the victims. But of course, the judges don't accept the argument. Judges accept the argument that they want to make it harder to sue the government. And yeah, so that is about it. Now we go on to omissions. So omissions, like I say, but there is no general duty. But you see, the definition of negligence is you fail to take reasonable care. You breach your standard of reasonable care. So you fail but failure, there is an omission by itself. So in principle, what is the difference between omission and commission? The guilt is very similar, but they define it by actions lah, your physical acts lah, okay. um, yeah. So for example, they got this towing wise the case. The road was very dangerous, people already complain, you know, a lot of accidents and all lah, but the local council never go and fix the thing. So there's accident, I think people injured or somebody die or what lah, not sure, forgot already. But then they say that because the council they have no obligation to fix the road, you know, they don't have to confer you any benefit. Right. So this is the adoption lah of this, one of the examples lah of omission. But there are 4 exceptions, right? Lord Goff, I think, came out with the 4 exceptions. One is if you created the danger. So you can argue you build the road ma. When you build the road, you build it so dangerously ma. So you have to fix it lah. You created the danger lah. Right? When you light a fire, in a fire spread to the whole building, you created the danger ma. Now you have to call the ambulance or you have to call the fire brigade ma. One more assumption of responsibility. If you tell the fellow, you know, I will do this for you, then you have to do it lah, because the guy is relying on you now ma. Right? He's relying on your protection. If you deprive the other person of a better outcome, so if you take the case he took a drunk guy out of the pub, out of the restaurant, and he put it somewhere else, but he left the guy there and then the guy died, you know. When if the drunk guy was in the restaurant, many people could have helped him, so you deprive him of other people helping him. And one more is if people expect you to act lah, then you have to lah. So these are some of the exceptions that came about, was recognized by Lord Goff. I think Lord Goff, I forgot the case already. Yeah, but this is very common. You can get it from the textbooks. So, but you must remember that he abandons the parable of the Good Samaritan. You see, when they came out in Donahue and Stevenson, Lord Atkin, the neighbor principle came from the parable of the Good Samaritan. Okay, the parable of the Good Samaritan is, the story it goes like this. The guy was robbed. Okay, and when people passed by him, he was robbed and he was beaten badly injured on the road So nobody helped him, you know, until one guy helped him, bring him to the hospital, you know, and pay for his bills until he recover So that guy is called a Good Samaritan because the Samaritan is like a person it's like a race like that So it is a story about omission, you know. The reason why those 2 guys, the first 2 guys who didn't help him, is an omission because they failed to act precisely. But the principle now they don't recognize this. Okay, they don't recognize the obligation to act. Okay, so but other countries got, you know, like France they in their, you know, France there is obligation to save somebody if it doesn't cost, if it's easy for you to do something and it's not risky for you you know, you can succeed and it's not any risk to the guy. Then if you don't go and save the baby from drowning, then there is some criminal other countries there's civil remedies, but so this is one of the observation about omission. Now we go to breach of statutory duty. So this one not really covered in the exam if I'm not mistaken, but in the textbooks they do talk about it a little bit, because it's not very clear when is a breach of statutory duty, when do you fall under public duties, right? But the main thing is statutory duty is harder in most generally because why, you have to prove the statutory parliamentary intention when they write the statute. And if it's silent, then the presumption like I say you know, presumption there is no intention to sue under tort. Right, so you have to pass that interpretation thing. And and they always say, but it doesn't matter whether it's a power or a duty. You know, the statute gives you the power or the duty, you know, to do it. You have to still see, the main thing is you have to see whether it is first you have to see whether there's a parliamentary intention. Even if there is, then you have to see, is there a discretion or is there an obligation. If the statute gives a discretion, means you want to send the police to the house or you want to send ambulance or you don't want, it's up to you. If the wording is discretion, then how you want to sue, right? But if you say you must do something, then if they never do, then yes, you can sue. Or if they do it negligently lah, right? Then you can what lah. So there's two difficulties there, right? Um, and they say community expectation cannot lah. Even though everybody say the police expect to when they say they'll come, then they must come, right? So yeah, and police, right? It was the case of Hill and Chief Constable in 1989. They misunderstood, from 1989 up to 2015. They say that nobody can sue the police for negligence because they understood as a general immunity for, I think for general, no matter what they do also cannot, They were some people lah, they misunderstood lah. And then Hill and Chief Constable in 2015 clarified that it is not, cannot, not necessarily cannot lah. Yeah, so now even can lah, but police is like I say the hardest lah for omission lah. Whereas ambulance, if the ambulance say they will come and they never come, then there's a duty of care. But police, no. If police say if they really never come also, there is no duty of care. Unless you can prove voluntary assumption of responsibility lah. But they will say, it's my job to tell you, or come. So police is the hardest lah. So fire engine also. Okay, now we go to HRA. So HRA is a specific act only available in UK, where they have the rights. If you breach any of their rights, you can sue for damages. But the damages most of the time is not as high as negligence lah. So it's a breach of the right. You don't have to be concerned about whether it was negligence, intention, as long as your right has been taken away and the other side has no good reason why they infringe on your right, then they will award you damages lah. Okay. So for example, if your property get damaged, you can sue lah for the right of enjoyment of personal property. If they take away your life, you can say the right of life lah, right to freedom of life. Took away my right. If they didn't endanger you also can. If they imprison you, then you say you must be free from there's a right to freedom lah. You cannot put you in prison for no reason lah. So it's rights based lah. So some say they want to merge. Right? Why we have two? Since we have the Human Rights Act, why do we need? Why can't we just say because you infringe my right, so I can sue you on the thought lah? But so far no lah. So far the courts they want to maintain two separate distinct things. One, like I say lah, main reason is because like if you have a battery you have to prove the guy intended to hit you, right? Whereas human rights you don't have to prove he intended, right, or he was negligent or what. So human rights is a distinct category lah. So is conclusion is we want to prevent the courts want to prevent abuse of the system lah, because negligence is like you can always sue. So if you say there is a duty of care of the police, does it mean on the one hand, if you say there is a duty of care, you are making like the police every time they make a mistake, they have to compensate the the victim or the plaintiff or the claimant or what? Every time there's a mistake, are they supposed to pay or not? On the other hand, if you say there's no duty, even if they're super careless also, they don't have to pay at all because there's absolutely no duty. Okay, so they are faced with these two choices, right? They don't know how to come in between because there is no proper precedent or how to balance it out. So they side with they prefer to say that there's no duty so far unless it's really clear cut okay, unless but it's a very bad example right? Because the government is supposed to set the example for us because we know that uh, they are careless, right? They don't want us. They say if we allow you to sue the government, everybody will be dependent on the government, will be lazy, you know. But now, when you say there's no duty, the government become lazy. Like Malaysia, like that, okay, public perception lah, okay. Maybe now improve, but in the past, the public sector in Malaysia are famous for what? You know lah, sitting on their ass, you know. You got 3 people to do one guy's job, for example, or 5 people to do one guy's job. Every day just, you know, passing paperwork around, or they got all sorts of rumors that go around lah. Whether it's under table money, whether it's you know, right, a lot of things and this is going on for many years, 20, 30 years also. It's already known, well known already. So now the government is lazy, you know. Now it's not the citizens who are lazy, you know. In Malaysia lah, I don't know about UK, because UK they always say the government got no money lah, you know, we want to cut back expenditure lah. But UK actually got a lot of money compared to Malaysia, you know. Malaysia on the other hand, we got a lot of debt. Our GDP to debt ratio is super high, right? Government always say we got a lot of money, you know, no problem. Economy doing well, job no problem, you know. Yeah. So, but the government now is a problem. Government, we are left to fend for ourselves. You know, if there's a pothole, you ride motor, you too bad lah. Like federal highway and that. You know, last time in a few years ago, people say, you know, I ride on the motorcycle lane on federal highway, so bloody dangerous. I don't even dare to go there. I rather go on the road I rather mix with the cars. You know, people are complaining, came out in the newspaper, but too bad lah. I don't know why people fall down because of pothole or very dark or very, you know, very easy to get accident in the motorcycle lane. So they come to the car lane. So the government is the one, right? If you don't right lah, but it's very hard to make politics because it's mixed with politics. So you need the opposition to lobby the government, to pressure the government, right? So the opposition have to get our support, like sign petitions or something, and then go and present to the government lah. But it's an issue lah, because a lot of issues in Malaysia, like people die in the police lockup lah, like Teo Beng Hock found dead in the MACC custody, right? He was taken in custody and later they say he committed suicide, but there's no reason for him to commit suicide. How he died, you know, what kind of policy you have to prevent all these things from happening. Maybe he was murdered, right? But yeah, of course they say non-justicable lah. But later on they had legal issue for Teo Beng Hock, right? They compensated him, and then they had some inquiry or something, a Sukaham or what inquiry and all lah. Right, they found the Sukaham or something, found the MACC officers to be negligent or something but I don't think they succeeded in the court lah. So but what can we do, what can we learn, right? Is you see, one thing I learned is power and responsibility is very closely connected, you know. The right way to look at it is, if I have responsibility, then I have power, right? When my boss give me a job, okay, he give me the job, automatically I have power to do my job, right? If I have no responsibility, I won't have any power. You know, you don't get power without responsibility. But now they are saying, the academics, right, they are saying no. They say you got power. When you have power, that means you have no responsibility. The definition of power is you are free to break the law. You are free to do what you want. That is the definition of power. You know, you're above the law. So you are. That is totally not following the rule of law, right? That is not the correct definition of power. Power comes with responsibility, but of course the courts don't reason this way lah. Courts say because you have power doesn't mean you have responsibility lah. They call it don't call it responsibility, they call it duty of care lah, for negligence lah. Okay, and so we cannot just say that we are nobody. I'm just one guy. I cannot do anything mah, right? We got no power mah. But we must know that all of us contribute to the government in taxes. If we didn't pay taxes to government, government also cannot do their job, cannot serve the public. So we also have a duty to pay taxes to the government. Right? We also have responsibility to contribute lah to the economy, to the government lah. Right? Because government relies mah. If nobody wants to join the police, let's say, because policemen and doctors, you cannot look down every time you want to sue the police, want to sue the government, want to sue the doctors. These guys are like the good guys, supposed to be, right? When doctors save your life, you got heart attack, you got accident, doctors are saving lives. You don't look at them like these guys are super always negligent or that. When you look at the police also save life, right? They stop crimes from happening, right? Prevention of crime. They are, we are part and parcel of helping them also, right? We are who builds the house for the doctors, who help the police cook their food when they go to the restaurant, for example, who teach their children, need teachers. So even though they are the front lines, we also contribute in the society, right? So we are, in a sense, we don't just say, we have to look at it in terms of together lah. Power and responsibility lah is together, and we cannot change the government. Like, I doesn't mean just because I criticize the system or the law or what it will change, right? But we cannot control what other people will do. We can control ourselves, because why? We have a lot of time this negligence thing is you intended to be careless. You intended not to take reasonable care, right? So it's actually intention. A lot of time is when I, let's say, do my job or what, I don't have so much time. I only have allocate. So I'm actually, even though you can say I'm negligent, but it's intentionally negligent, right? But we always want to make sure that we cover everything. The moment somebody say there's a risk, like in the company, there's a risk of fire, there's a risk of accidents, some people will sleep when the floor is slippery, you have to remedy it. Like, we want to be as intentional as we can, right? Even if you are negligent, like when I make this video, I don't give you the cases, I don't put PowerPoint slides, the thing, right? You think it's carelessness, or you think I intentionally do it this way? Right? So we want to try to be balance the cost and benefit of doing things that we do, and don't be careless to be intentional, but be intentional to be careless is okay, right? I consider the cost and benefit intentionally. If I'm careless, then never mind, because I already look at the way the cost and benefit. But you're careless to be intentional, it means you're not planning for the future. They say fail to plan is plan to fail. Then there's an issue. So yeah, okay, yeah, that's all. Thanks.